Hello everyone, my name is Niharika from 4BBA FNMB. Today I'll be talking about Shabnam Hashmi versus Union of India and ORS 2014 Supreme Court 1281. The facts of the case. Shabnam Hashmi was a public-spirited individual who approached the apex court of the country under Article 72 of the Constitution to recognize the right to adopt and the right to be adopted under Part 3 of the Indian Constitution. As the petitioner, she also requested the court to lay down guidelines relating to the adoption of a child by individuals irrespective of their caste, religion or creed. In addition to this, a direction was made to the respondent Union of India to promulgate an optional law. What were the issues of the case? First point, whether the right to adopt and be adopted is a fundamental right. Second point, in the case of a contradiction between secular law and personal law, what is going to prevail? Third point, whether caste, creed and religion affects the adoption procedure. The law related to the case here is the Juvenile Justice, Care and Protection of Children Act 2000. On analysis of the case, the following can be observed. The prayer that position of the petitioners has been fructified by the current march that has taken place in this sphere of law, gently nudged by the judicial verdict in Lakshmi Kant Pandey versus Union of India 1984 SSC 244. The supplemental, if not consequential, legislative innovations in the shape of the Juvenile Justice, Care and Protection of Children Act along with its amendments. The Act enables prospective parents to adopt children and follow the norms of the Act, but at the same time does not compel anyone to follow it, instead enables him to follow his personal religious laws as well. The court also points out that though personal laws must be honored, they cannot dictate the operation of the provisions of an enabling statute. An optional legislation that does not contain an unavoidable imperative cannot be stultified by principles of personal law, which, however, would always continue to govern any person who chooses to so submit himself until such time that the vision of a uniform civil code is achieved. The court then finally signifies that in regards to whether adoption should be made a fundamental right, that the present is not appropriate time and stage where the right to adopt and the right to be encompassed by Article 21 of the Constitution. So who is Shabnam Hashmi? She is an Indian social activist and human rights campaigner. She finally ended up adopting the 1-year-old child who she was fighting for, and before the case had ended, she only had guardianship over her. In conclusion, the Supreme Court in this case ruled any person under the Juvenile Justice, Care and Protection of Children Act 2000, irrespective of their religion, can adopt a child even if it is in violation of their personal religious law. This is due to the fact that Juvenile Justice Act 200 is a secular law that enables any person regardless of religion to adopt a child under the provisions of the Act. However, in regards to the petitioner's right to make adoption of children a fundamental right, the Supreme Court has chosen to deny such requests due to the fact that it is not possible due to the various different contradictory religious beliefs in our country. The judgment has allowed Shabnam Hashmi to now formally adopt a 1-year-old girl who was from an adoption home, who she priorly only had guardianship rights over. The significance of this judgment is that now the judiciary has passed an important judgment that provides uniformity in laws in regards to the adoption process within our country. Additionally, it has stated that in regards to the issue of whether adoption is a fundamental right, that they chose to exercise judicial restraint, and the legislature is a far better organ in terms of deciding the voices of the people in regards to this issue.